This is Too Many Lawyers. I'm Royal Oakes.
And I'm Connor Oakes.
And Connor, I think we ought to remind folks what the show's all about. I'm kind of conservative. You're not so much.
True.
I'm an old guy. We'll just say baby boomer.
Yeah.
You're a young millennial. And we disagree on just about everything, but no food fights. That's the whole idea of the show, is that we can agree or disagree, but with love, respect, humor. So aren't we great?
We're the best.
Pat on the back.
Yes, exactly.
Well, I think we need that.
Sure.
We've needed it for a long time.
Sure.
So that's what the show provides. And thanks to everybody who has been sticking with us for these many years. So we want to talk about public nudity today. Why? Because Gloria Allred wants us to talk about it.
Everybody's favorite topic.
Yeah, you may have seen her in the news. She represents a lady who was trying to take a flight on Delta Airlines, the friendly skies of Delta, but they weren't so friendly because apparently she wasn't wearing a brassiere, as they used to say. And so they kicked her off, then they let her back on. Maybe she dropped Gloria's name. I don't know.
Mm-hmm.
So we're going to get into the whole issue of whether Gloria is right or not and how far we should extend it. Should ladies be able to, walk along the beach topless? Should they be able to take their shirts off on the flight? If we're going to let a guy do it, maybe it would be in violation of Frontier's rules. So that's our main topic. At the
If you're flying Frontier Airlines, there are no rules.
Yeah, that's true. At the end of the show, our feature Guess the Verdict, where I give Connor the facts of a case and he gets to guess the outcome.
Everybody's favorite game show.
Yeah, it's America's favorite game show. And today the topic is assault and boobery.
See, we're staying on the topic. It's very consistent.
Yeah,
I like it.
We had a similar show last week. Anyway, assault and boobery. There was a very serious personal injury that occurred inside the confines of a topless bar. So we're going to find out who wins and who loses in that suit. Before we get to the public nudity issue, just a quick follow-up on last week's show about the CEOs and the assassination. And people,
of course.
People continue to be really shocked, I think, at the extent to which some members of the public are happy to sort of applaud this extreme measure of insurance reform. And the news story is that there's a guy who is the founder of a socialist apparel brand. I didn't know there were socialist apparel brands. Does that mean everybody has clothing that's equally nice?
Yeah, that's probably it.
I guess. Yeah. I don't know. Anyway, he's called online to the death of corporate executives, and he's planning to sell a deck of cards of most wanted CEOs. I'm going to hold the picture up here, and those of you listening to our podcast but not watching it, this is a reminder. If you want to see the podcast, just go to Too Many Lawyers on Video, ! Just like Jeb Bush Low Energy with the exclamation point.
Yeah,
and you can see this.
Of course, calls to mind the famous deck of cards that was created in the aftermath of 9/11.
Mm-hmm.
That was the FBI, the U.S., Federal Bureau of Investigation, or CIA, or whoever's top most wanted international criminals, almost all of whom were the folks who were blamed for 9/11. So you have all the architects, and Americans bought these, in gas stations all over the country.
But did those cards have a bullseye on them?
Oh, I don't know that they did. I mean, obviously, the goal was to take down Saddam Hussein, to take down, all these. They were terrorists, right?
They were terrorists. They were 9/11 people. Yeah. Now, the picture here, and I'll explain it, there is a silhouette like you'd see at a gun range.
Of course, yes.
With bullet holes right in the middle.
Yeah.
It's funny, there's a little emoji of a heart in the absolute middle, and of course, everybody knows it's off to the left.
Yeah,
anyway, most wanted CEOs.
Yeah.
Do you think, Connor, that this socialist apparel owner maybe has crossed a line in publishing a deck of cards with the silhouette and the bullet hole for 52 CEOs of really bad insurance companies?
It definitely... If this is a person who is, if this is a project that actually includes real people with their real likenesses and any other information, or simply their name and likeness that might allow you to go in our connected world, go find out more information easily about these people, especially given the contextless nature of a playing card, right? It's the ultimate there's no information here, right? It's not an expose or on UHC written in the Atlantic with a 50-page well-researched piece of journalism talking about how this person is doing health insurance wrong, right? And we should change the laws or whatever, or even just saying they're a bad person for doing this. That's a very different thing than a bullseye, in the same way that we had political ads. I think it was back in the Obama era, there were some Democrats who were in political ads with bullseyes on their faces, indicating that the super PAC that had been newly legal after Citizens United was targeting their seat for an upset, right? And that was a bridge too far. That
little metaphor, a violent metaphor.
Very. It provoked a big, uprising of public sentiment that, hey, this is calling for violent action, whether implicitly or not, and that absolutely crosses the line. I think that if this, deck of cards were to actually get produced and not just be something that people talk about as an art piece, as a theoretical, a hypothetical, if it were to get produced and have real human faces on it, I think it would be a bridge too far.
Yeah. So Elizabeth Warren has weighed in on this, and Elizabeth Warren has a big but. You want to know what the big but is?
Sure, hit me.
She says, violence is never the answer, talking about shooting CEOs.
Right.
But people can only be pushed too far.
Right.
Thanks, Liz. I don't think that sends the right message. I think her fellow senator, John Fetterman of Pennsylvania, had the better approach. He said about this guy who shot the CEO, he's the asshole that's going to die in prison. A sewer is going to sewer. That's what social media is all about. So I think he had remember, he had 2 children. They're going to grow up without their father. It's vile. And if you gun somebody down that you don't happen to agree with their views or the business they're in, I'm next, they're next, he's next, she's next. So I think Fetterman, I've always been a big fan of Fetterman, as you know.
Yeah,
because I love hoodies. I think he has the better take.
Ever since Fetterman had that stroke, he's had a slightly more conservative take on things than when he was when he pretended to be more liberal in order to get elected. But this is obviously that big but that you mentioned, the big conversational but of whenever something bad happens, people want to say, that was bad. But, and it's the same but that liberals have been complaining about for decades, of course, from conservatives in, applicably, relatedly, the gun control debate. Yes, Sandy Hook was a tragedy, but let's not, enact gun control or whatever. And people look at that and go, you can't, by putting a but, you don't just obliterate everything beforehand, right? You are acknowledging, we should acknowledge every tragedy should go into the calculus of how we approach these things. And a murder of a CEO, even if he was a bad guy, has to go into the calculus about what, our national conversation about guns and gun violence and, whether vigilante justice is accepted, lauded, tolerated. It should go into our calculus about, are we creating the society we all want to live in? Are we doing the right thing? Is this the right way to live and regard one another, treat one another?
Right.
And of course, I'm not a fan of the guy who got killed because of his business practices, the way he runs his business and the way he makes his money. I would agree with a lot of the commentary about his company and his business and his doings and how they were the wrong way to do it. But the conversation that leads to, therefore, we should pull out the guillotines is real. We should all remember how the French Revolution went, right? Glorious, historically important, a great leap forward in terms of holding the monarchies and monarchists and the elites responsible and responsive to the needs of the people. But when the guillotines came out, it inevitably, in that revolution, as with every other revolution, a lot of people got unfairly guillotined. Yep. It was just very easy to start saying all my political opponents should be guillotined, my neighbors that I don't like should be guillotined, my business competitors should be guillotined for their politics, of course.
The butcher who cheated me on the slab of pork I bought.
Yeah, this is inevitable, right? There's a reason that the state has a monopoly on the use of force in a society, because the state should be more responsive than the mob. And mob justice is, of course, never never the way to go.
So, in other words, there's a yes, but applicable to a lot of different arguments.
Yes,
you're
true.
right there. All right, so here's what we want to do, turning to the public nudity issue. We prepared a 2-minute news package talking about Gloria Allred's situation and the lawsuit that she wants to file. We're going to roll that right now. If you're listening to the podcast, not to worry. There's going to be enough talk during the news package. You'll be able to follow it just fine. If you're watching it, it'll be even better because, well, given the subject matter, it's a real eye-opener of a news package. So go to Too Many Lawyers on video. So, Joey, please roll the package, and then we'll come out of it and talk about it. Should women be able to fly the friendly skies unburdened by a bra, or perhaps in a see-through dress, or topless? We're not talking about the dream of a teenage boy here. We're talking about serious legal issues.
I was targeted and humiliated.
Gloria Allred, attorney for the woman, says it's ridiculous that a woman's breasts have never taken down an airliner. She wants an apology and a change in Delta's policies.
If there's a wrong, remedy it, right the wrong. It's simple as that.
It seems like Gloria might have a point. She thinks it's illegal sex discrimination for public nudity laws or dress codes to be different for men and women. Others argue, get used to it, Gloria. In our society, women's breasts are sex objects. Now, when it comes to man boobs, not so much. But some want the sexes to be totally equal when it comes to what has to be covered up. In fact, some folks seriously say clothing should be optional, at least in some sections of some cities. Now, come clean, Gloria. If you were queen for a day with a magic wand, would every seashore be a topless beach? Instead of,
what's their head?
It'd be off with their tops. Would every public nudity ordinance just be blown up? Critics of Gloria's position say her quest to wipe out legal distinctions between men and women is a nutty obsession with ignoring cultural and biological differences between the sexes. On the other hand, societal norms do change. Decades ago, stuff that was considered risque seems positively quaint by today's standards. So the beat goes on. The battle of the sexes has become a high-altitude fight. One more way, your next trip to JFK could land you on YouTube. For Too Many Lawyers, I'm Royal Oakes. So there you have it. Gloria Allred has once again teed up a very important public policy issue for us all to sink our teeth into.
Yeah.
We're going to have a very brief pause. We're going to come back, and I'm going to dump on Gloria, and who knows, maybe Connor will admire and appreciate her. Stick with us. This is Too Many Lawyers. Welcome back. This is Too Many Lawyers. I'm Royal Oakes.
And I'm Connor Oakes.
And we are talking about whether or not Gloria Allred is a good point, representing a woman who tried to get on a Delta Airlines flight, sans bra. I will say that this woman is not shy. We have a couple of pictures of her out on the town. Her name is Dijette Kiwi. That's her stage name. And so here she is. And funny thing, she's wearing, as a bra, a belt.
So she does own a bra.
Yeah,
well,
I never thought of using a belt as a bra. Maybe it's because I'm a guy. And here she is also on the town. It looks a little chilly out there. So she's wearing a big fur coat. But on the other hand, she's not wearing a whole lot else.
Yeah.
All right. So should we have topless beaches? I think that's really the question, because Gloria can talk about whether or not Delta was mean to her and it's a double standard and so on, and we weren't there, so we don't know if it was just like, wowzer, she's not wearing a bra and she's wearing saran wrap on top of it,
right.
Or was it sort of a gauzy, like a dress shirt where she was very prominent and all that,
right?
But ultimately we have to get to the question that a lot of people say, why can't gals walk around on the beach topless?
Yeah, why
and
is
maybe nobody should be able to go on the airplane topless, but that's ultimately the issue. Where do you come down on that topic?
Yeah, I mean, where is this? Where's the source of a social taboo? And should we carry that forward? Should we be open to
I think Hugh
shifting?
Hefner is the source of the taboo, because if there were no taboo, he wouldn't have been able to start Playboy magazine in 1955.
He certainly benefits from the social taboo.
Oh, yeah.
Right?
Well, he did.
Yeah.
He's no longer with us.
That's a good point. Yeah. Is that? Sure, it sounds right. You didn't keep track. R.I.P. I guess. I don't know. But yeah, the source of a social taboo. A lot of people will tell you there's multiple sources, of course, but nudity taboos are pretty common across different cultures and have been throughout much of history. But if you track nudity taboos, they're very frequently applied with a double standard. Throughout human history, very frequently, it is women who are the subject of nudity taboos that are really important and culturally, socially important. And that's not to say that culturally or socially important practices around,
But what's wrong with the double
whatever.
standard when women and men are different physically? At least most are.
Well, yeah, the purpose of a nudity taboo should be sort of examined, right? When we think about, well, what parts of history, human history, do we want to carry forward in our society and embrace, and which parts do we want to leave behind? There were double standards about land ownership and voting and other, until the 80s, women in America couldn't open checking accounts without their husband's
Couldn't
approval.
vote till 1920.
Right. I mean,
And they voted in the handsomest president in American history.
Calvin Coolidge. Oh, wait.
No, it was Warren G. Harding.
Something like that. Yeah, close enough. I like Calvin, but that's just, my taste. Whatever. So until Antonin Scalia, famous Supreme Court justice, was arguing in the mid-'80s that women should be able to be kicked off of juries, for example. I mean, we've had very
Really? I didn't
recent-
know that. What was
Yeah.
his basis for that?
His basis was the defendant should think that, I think
Oh,
women
you mean
act
for a
certain
peremptory
way.
challenge, a free
Exactly.
strike,
Exactly.
whereas you may not strike based on race.
Right.
He was saying you may strike based on gender.
Exactly. Yeah. Exactly. I think this will give me a better chance in my case, so I'm going to strike women or whatever. Right. That's another great example of how we did not consider women's right to sit on a jury and be part of the government that determines what the law is and how it's applied. We didn't think of their rights as particularly important, as important as the defendants. So we had these double standards based on gender, and it's not like they're all gone, right? We should be constantly re-examining, as we did as recently as the 90s, whether women should be treated equally in that context and in many other contexts. And it's this great sort of march forward. And I think it's an incredibly important, apropos thing to be thinking about now, right now, not just in the 90s, not just in the 2000s, but in 2024. Barely, we're still in 24 as we record this, because we're dealing with this similar puritanical panic about trans people and other
But if the
different
vast
categories.
majority of Americans aren't experiencing a puritanical panic, they just happen to think, and they're always going to think, no matter what Gloria Allred says, that we should not have topless beaches. I mean, is that such a bad thing to have, sexual mores, certain parts of certain people's bodies as sexual objects? I mean, are you really going to be able to talk folks out of that?
Well, it's not that you should be considering, is it impossible or is it too difficult to talk folks out of it? It's okay to have certain standards and have those standards evolve. But in my view, we should be constantly scrutinizing whether those standards, as we are currently abiding by them, are leading to a society that is somehow unequal or somehow stratified, right? I don't think Gloria Allred thinks that, that nudity shouldn't be taboo, that we should somehow try to retrain society to tell them that people's genitals are not
Why? What's the difference between somebody's junk and a woman's boobs? Why shouldn't society be able to say, you know what? I think you have to cover your junk and you have to cover your boobs.
Yeah, I mean, it's a very you're posing a very important and relevant question here. You could be some sort of appeal to biology type person and say these are secondary sexual characteristics. Well, a man's nipples are as much a secondary sexual characteristic as a woman's nipples. Yes, one is useful for breastfeeding, while men's, you could say, is vestigial, although there are those that argue that men have successfully breastfed in the past. It gets to the, and then the present, it gets to the question of sexual dimorphism as a social construct.
Well,
how
those are a lot of big words, but isn't the bottom line that the American public feels, and don't they have the right to feel differently about guys' boobs as opposed to gals' boobs?
Well,
on the beach.
Yes, and of course people are entitled to feel differently about these things.
But why shouldn't the law reflect that? Because of, don't we have a right to have mores, and don't we have a right to have collective views about what's a sexual object and what isn't?
Everybody has a right to views, but I'll say what the law reflects is not necessarily what the American public believes or embraces at that one moment. We all currently, at least you and I both, and probably many of our viewers, agree that the Supreme Court was correct in upholding same-sex marriage nationwide as a right. And it did so ahead of public opinion polls. They were trending that direction, but the Supreme Court got ahead of that trend. They're behind in many other trends, but at the time when California had shamefully succeeded in adopting Proposition 8, which shot down gay marriage in what used to be a bellwether blue state, right? A real, the way California went, therefore went the progressives in the rest of the country. California lost that battle. We went the wrong direction. And then the Supreme Court saw the reaction of the American public, and in the years following turned that over and said, actually, we're going to uphold gay marriage nationally as a right for gay people. That was a victory for society. People now have looked back on that and said, hey, the Supreme Court did a really good thing there, even though they were violating the social norm. They were ahead of their time.
I think I disagree with you, though, because my perception of the Supreme Court is the opposite. I think they put their finger in the wind and try to figure out what people really like, and are desperately worried about torches and pitchforks and the fact that, what army are you going to use, Chief Justice, to enforce your decision?
Right.
I think they're behind. For example, the Loving case in the 60s, where the U.S. Supreme Court said these interracial marriage bans, they're out of there. I think that's because people already felt that way. And I think when it comes to gay marriage, I think the U.S. Supreme Court several years ago realized this ship has sailed. Everybody in America, most everybody's very comfortable with it. So we're going to endorse it. So I mean, in a lot of cases, I think they're behind because they're fearful.
They often are. And that's why I pick out the gay marriage case specifically, because at the time, if my memory serves, you've got public opinion polls that say no, but narrowly. And the Supreme Court says, we're going to go against the 52-48, right? And that's why it's such a notable case, right? The law doesn't need to necessarily reflect the social norms at the time in this one place. And America is not a universally, well-stirred soup that all becomes the same temperature, right? It's a chunky stew of Alabama and California and rural and urban.
I love this
East
metaphor.
Coast and West Coast and everything. And you
Brawny. No, that's a paper towel.
When the law comes in and says, hey, we're going to stir the stew a little bit, we're going to set the standard up a little bit, and when the average temperature, when the rural parts of the stew get really, really hot on a subject, and the Supreme Court should come in and stir the stew and even out the temperature across the whole country and have one rule for what we want our society to look like. The stew can change later. It can chill out. It can warm up later. But right now, we're equalizing and spreading the temperature evenly around.
If you were king, and like in the package with Gloria had a crown and a magic wand,
that was really good.
Would you say, hey, San Francisco, they've got sections of the city where nudity is just fine.
Right.
Would you say that, let's go that route? Let's let neighborhoods vote to have public nudity?
I'm not specifically... I don't specifically think that this is the kind of issue that local control solves better than a top-down, or vice versa.
What if tourists from Tacoma wandered into that section?
That's true. Tacoma is pretty, even though it's Washington, it is pretty conservative. While I don't think that there's a one-size-fits-all solution to this, or even a local control instead of one-size-fits-all answer to this. I don't think it's a specifically an issue that is solved better, closer to the people, or something like that. I think that often many problems are solved closer to the people, but not always. I mean, there's a reason that racial integration of schools had to be enforced by the National Guard, because local control wasn't going to work, right? The people locally were not about to go start integrating. So in my view, it is an important conversation to be had around sexual mores and the idea of imposing morality, especially around sex and gender differences, on our society. We should have a very skeptical eye towards it, because with what's happening in American politics at the moment, which is populist fascism, right? The Trump administration coming in, Project 2025. The branding technique is populism. Hey, we're going to address your specific voter interest. We're going to make your life better. We're going to lower grocery prices. How are you going to do it, Trump? Well, now that I've been elected, it's actually going to be really hard, I promise. But it's populism, and it's the risk of fascism, right? It's the risk of governmental control at determining how society should be run from the top down. Those things very frequently, populism and fascism, especially when combined, two great tastes that taste great together, come with religious extremism, imposition of strict sexual morality. You'll look back at countries like Nazi Germany and other fascist regimes. It's very useful to be able to otherize a small minority or a group like women, to say we're going to control. I mean, when you look at the rise in the frequency of teachers around the country in the post, Trump victory and the post, manosphere social media world out there, where young teens are going on YouTube and TikTok and Instagram Reels and all the rest and getting inundated with Andrew Tate-style psychology, where they're being told that they're better than women and how funny it is to go out there and chant in classrooms, your body, my choice, ha ha. This is the world we live in. This is the direction that the youth are being educated in. And we have to fight Gloria Allred style, fight tooth and nail every step to maintain sexual gender equality.
We have to use Gloria's style? You said we have to. I don't want to.
Freedom and the fight against fascism and the fight for gender equality, these are fights that need to be fought.
Okay, but how do you draw lines? Now, you raised an interesting point I want to get back to, and that's jury selection.
Yeah, sure.
And most of our viewers and listeners probably have had the experience of sitting there in court and the lawyers are quizzing them and so on. It's a two-part deal.
Yeah.
The lawyers ask questions of the jurors, and then they turn to the judge, and maybe the jurors are out of the room, and the lawyer says, "Judge, she's biased. She hates me. She hates my client. She hates all insurance companies, or she hates all black people, or whatever. You've got to get rid of her based on what she said." And the judge either says yes or no. If the judge says no, well, there's plan B. And plan B is each side gets 8 free strikes. They're called peremptory challenges. Mm-hmm. And for a long time, it was just strike for any reason. You don't have to explain it or defend it. And then somebody realized there's some lawyers that are striking people based on their race.
Yes.
So the U.S. Supreme Court, I think, came along in a Batson case and said, if the other side says, "Judge, I think he struck a juror because of race," now it's the burden of the striker to say, "Oh, no, Your Honor.
I have another reason.
Yeah, I have another reason.
I didn't like his haircut." And
if the judge doesn't buy the other reason, then the juror gets to stay. So here's my question for you. How far does that go?
Yeah.
Well, what if the strike was because of her gender?
Right.
What if the strike was because she's a millennial? What if the strike was because of her
religion or
her religion?
Else. Sure.
Exactly.
Yeah.
What if the strike was because she's poor?
Yeah.
Should we climb into the head of the trial lawyer and say, "No, we think all of those things are politically incorrect, and therefore, you've got to justify. You got to have. Well, what are you going to say?
You're
I don't like her hair color. Are we going to let the trial lawyers strike because of hair color?"
You're absolutely right. This is an important question to ask, an important debate to have, and the debate gets down to the way it's currently handled in law, of course, as you understand, is there are certain constitutionally protected classes. And those classes are not all written in the Constitution, right? The Equal Protection Clause does not say on the basis of being transgender or whatever. It doesn't say on the basis of any other specific thing. It just says
and it certainly doesn't say because of race, because the people who wrote the clause had slaves.
Right, exactly.
Yeah, that would be inconsistent.
Right. So we now have later lawmakers, judges, and Congress people, they're aides who write the bills, who interpret, but mostly judges, who interpret the law and the Constitution and all the text around it to find what we think the society should look like and which categories of folks should be protected from, for example, in this case, a peremptory strike. You can't strike someone on the basis of their religion or now, Antonin Scalia, we've evolved a little bit past your 1985 decision on the basis of gender. You can't strike someone. Why is that? Because it is more important to have women be present on juries, or men to be present on juries if they were striking all the men and keeping all the women. It is more important to have an equality of gender in the jury pool because they're the ones that decide how the laws apply.
What if you want to
people.
strike all lawyers?
Well, that's the thing. Is
that okay?
Yeah, being a lawyer is not a protected class. Now, should there be more protected classes? In my view, yes. I think that it should be a stricter burden to be determined by striking. I mean, it's my job, right? I'm the lawyer up there striking people with peremptory challenges, right? I think there should be more regulation on me and my ability to strike people using my peremptory challenges.
Maybe every judge should have a DEI officer in the courtroom to help decide if the strike is legal or not.
Good idea. I mean, this is a context where you look at are poor people being struck from juries. If you can show me as a trial lawyer who's trying to win money for probably a sympathetic person, right, from maybe a big corporation defendant, if the big corporate defendant is striking all the poor people from the jury,
so that should be added too. Okay.
I mean, I think that's
all right, now we got it. Now we're going to tear it up. Peremptory challenge is gone because you've just created a situation where there's no basis for a peremptory challenge. There's nothing.
No, you're right.
I just have an instinct, Yeah. I don't like people with straight hair, curly hair.
Well, that's the thing. If people are out there doing it, and you're ending up with only rich people on juries, right? That's the question. Is it a real problem that is plaguing society at the moment, that poor people aren't being allowed onto juries? Or alternatively, that rich people aren't being allowed on juries and defendants are getting taken for a ride because the jury is full of poor people and there aren't enough rich people to go around, right? So if you have a limited number of peremptory strikes, it would be to the defense's advantage to strike the couple of rich people that show up. The juries are all made of poor people and the defendants are getting taken to the cleaners.
It's not a problem for you because as a trial lawyer, you win all your trials.
Oh,
so
yeah. I win every case. I don't have to worry about verdicts,
All right, speaking of verdicts, time for Guess the Verdict.
I love it.
America's favorite game show.
Good transition.
Give the facts of a real-life case to Connor, and he gets to guess the outcome.
I'm ready.
This one's called Assault and Boobery.
Oh, right, of course. I've forgotten that we're on the boob theme. Yeah, exactly.
Paul Shimkonis, a physical therapist from Florida, wound up needing physical therapy when he attended a bachelor party and suffered whiplash while getting a lap dance from a stripper named Tawny Peaks. He says she assaulted him with her size 68 double H breasts.
I don't know what that is, but it sounds really big.
Slamming them on his head, almost knocking him out.
Oh, my God.
He testified it felt like getting hit with a pair of cement blocks, as if he would know what that feels like, right? I mean, that's a lie right there.
Right, of course, yeah.
Sorry, Paul, I won't go into your last name.
Yeah.
So he sued the Topless Club for $15,000. Now, shocker here. I don't know how this happened. This case was selected by the People's Court.
Shocker.
To be on television.
Yeah, how did that happen?
But there was a decision, and so somebody won and somebody lost. So, Connor, you get to guess the verdict.
Well, given that it's the People's Court.
Well, no, why would you say that? I mean,
I'm sure it's a totally legitimate process.
That judge,
and the judge.
The guy who was on the People's Court for years and years, he used to be the presiding judge of the LA Superior Court. He was the head guy.
And then he decided to make that money. Let's go do TV, baby.
He went for the big bucks.
Yeah, exactly.
So, you got any thoughts about who might have the edge on this one?
I'm going to say, just broadly, we have a society where we think certain professionals should be held to a very high standard, and when they fail to meet that high standard, higher than the average person for what we would consider the concept of negligence, they're liable for a tort called malpractice. If you go to a podiatrist and they're operating on your big toe, we don't hold them to the standard of how would a reasonable person do trying to do toe surgery. We hold them to a really high standard, and we say, no, you've got to be not just a reasonable person, but a reasonably well-trained doctor.
Podiatric surgeon.
A podiatric surgeon, a specialist in this area, right? Mm-hmm. So do strippers qualify for that sort of category where we would consider them to be elevated to the status of, hey, this is a job that is inherently dangerous and takes a skill? Well, I certainly couldn't do the job. Even if you gave me the assets to work with, I guarantee you I would not be rolling in the tips, right? I do not have the skills and the experience and the riz to be able, don't worry about it, short for charisma, but don't worry about it, to be able to pull that off. So is she a specialist? I'm sure. Is she expert at her craft? I'm sure. Does her craft require us, recategorize things?
Stripping is not brain surgery.
Right, exactly.
Just to toss that in.
Yeah, exactly. And in this case, I would say that we're not going to hold her to a super high standard. It's not an inherently dangerous activity, and if somebody gets hurt in the process of it, it's not always going to be, or almost always going to be, the fault of the professional doing it, right? When somebody gets hurt during a surgery, it's very easy to say it was probably the surgeon's fault, right? It's probably not the person who has the toe's fault,
Could be the
right?
operating room nurse.
It could be, that's true. They're also held to a malpractice standard, a higher standard, but for nurses because they have different training. In other contexts where the situation is more equal between two regular people,
Right.
I'm going to put these folks as two regular people. Could he have been more careful around those large swinging objects that have a lot of momentum and mass? Maybe his negligence was contributory, as we would say in California. Contributory
You
negligence is our
sound like
scheme.
Tony Peake's lawyer.
So I would say I'm not going to hold Tony Peakes responsible for this guy's injuries because it was a likely consensual encounter for some, well, in this case, I guess twosome, but for some, a good time had by all, and probably any risk was borne by both participants, and they are aware of the risks as they enter into an interaction where two people's bodies are sort of, let's just say, bumping into one another.
So you think the club wins?
Yeah.
You're absolutely right. Defense won, according to the People's Court.
Yes.
Fun fact about the People's Court, everybody knows about Judge Wapner, made very famous from Rain Man, of course, on his own. He was very famous. So a judge I've known for a long time at the L.A. Superior Court is a fellow named Malcolm Mackey. And Malcolm Mackey was an actor in his 20s. He's now in his 90s. And when he was an actor, he thought of making it a real career, but he ended up going to law school and getting on the bench in Los Angeles. So before they picked Judge Wapner, they went to Malcolm Mackey, and they said, hey, you got your acting
You were an
background.
actor, yeah.
You look like a
You'd be
judge.
perfect.
Central casting, as
Right,
Donald
of
Trump
course.
likes to say. And so how about it? And Malcolm Mackey said, I don't know, it'd probably get canceled after 1 year.
Court on TV?
And he passed. He passed. And next thing you know, Judge Wapner, we're still talking about him.
Yeah,
And
because he's making Judge Judy
he's
money.
got thousands of dollars. Yeah.
Thousands of
Judge
dollars.
Judy money is $40 million a year. So
Holy.
congratulations to Judge Judy. I need a loan. All right, so we've done it. Thank you so much for watching or listening to Too Many Lawyers. We'll see you next week. Should women be able to fly the friendly skies unburdened by a bra, or perhaps in a see-through dress, or topless? We're not talking about the dream of a teenage boy here. We're talking about serious legal issues.
I was targeted and humiliated.
Gloria Allred, attorney for the woman, says it's ridiculous that a woman's breasts have never taken down an airliner. She wants an apology and a change in Delta's policies.
If there's a wrong, remedy it, right the wrong. It's simple as that.
It seems like Gloria might have a point. She thinks it's illegal sex discrimination for public nudity laws or dress codes to be different for men and women. Others argue, get used to it, Gloria. In our society, women's breasts are sex objects. Now, when it comes to man boobs, not so much. But some want the sexes to be totally equal when it comes to what has to be covered up. In fact, some folks seriously say clothing should be optional, at least in some sections of some cities. Now, come clean, Gloria. If you were queen for a day with a magic wand, would every seashore be a topless beach? Instead of,
What's their head?
it'd be off with their tops. Would every public nudity ordinance just be blown up? Critics of Gloria's position say her quest to wipe out legal distinctions between men and women is a nutty obsession with ignoring cultural and biological differences between the sexes. On the other hand, societal norms do change. Decades ago, stuff that was considered risque seems positively quaint by today's standards. So the beat goes on. The battle of the sexes has become a high-altitude fight. One more way, your next trip to JFK could land you on YouTube. For Too Many Lawyers, I'm Royal Oakes.